Good afternoon. I want to call to order this afternoon's meeting of the Senate Committee on Legislative Operations and Elections. Madam Secretary, please call the roll.
Senator Daley. Senator Cannizzaro. Senator Krasner. Senator Steinbeck. Chair Orenshaw.
Present. Please mark Vice Chair Daley present when he arrives, and Majority Leader Cannizzaro present when she arrives, or absent excused if they're not able to join us. Few housekeeping measures. I want to ask everyone to silence their electronic devices. If you wish to testify on a bill, please sign in at the table by the door. Please provide a business card if you have one to our committee secretary. For those joining us online, please be sure to mute your microphone when you're not speaking to minimize any background noise. To provide public comment or testimony telephonically, please dial the following number. And again, this is a new phone number. It may not be the number you've been calling earlier in session. That's area code 669-900-6833. Again, that's area code 669-900-6833. When prompted, provide meeting ID 874-0858-7004. Again, the meeting ID you want to provide is 874-0858-7004. Then you press the pound key. When you're testifying, if you're here in Carson City or down in Las Vegas, please turn on the microphone. Please state your name for the record, your affiliation with any groups if you have one. Then please turn the microphone off each time you're done speaking. If you're going to give paper copies of a handout, we ask for 20 copies for our committee members and the public. Electronic copies should have been submitted in PDF form to our committee manager 24 hours in advance of this hearing. We talk about controversial issues in this committee, but even so, we expect courtesy and respect in our interactions during the meeting, regardless of whether we agree with someone's position on an issue. Committee members will be using their laptops to view handouts and other documents. Please do not view this as a sign of disrespect. As a reminder, we may take agenda items out of order. We will take public comment at the end of the hearing. Each person wishing to make public comment will be limited to 2 minutes. I'd like to now open the hearing on Assembly Bill 123. We're very lucky to have Assemblymember Nadeem here joining us, and please come forward, and we thank you for presenting Assemblymember Nadeem and Mr. Attar Hasibullah of the Nevada ACLU also here. Thank you very much for joining us, and appreciate you being here to present the bill.
Thank you, Chair Orenshaw and members of the committee. For the record, I am Hanati Nadeem, representing Assembly District 34 in Clark County. I am pleased to present Assembly Bill 123 before you today alongside Attar Hasibullah, Executive Director of ACLU of Nevada. This bill addresses threats against and intimidation of candidates for public office. Unfortunately, I have had first-hand experience with receiving death threats in connection to a political campaign. The past year, while running for the Assembly, I was subjected to disgraceful campaign tactics that incited others to threaten my life. It was truly a horrific experience. I do not wish upon anyone, whether it be a fellow candidate, voter, or fellow Nevadan. As someone who was targeted during my campaign, I am passionate about reducing violence and intimidation during political campaigns. I believe AB 123 will help achieve that goal. With that, Chair, I will hand it off to Attar Hasibullah to explain the bill further. Thank you.
Thank you, Assemblymember Nadeem, and I'm sorry for what you went through. Mr. Hasibullah, thank you very much for joining us.
Thank you. Good afternoon, Chair Orenshaw, members of the committee. For the record, my name is Attar Hasibullah, first name spelled A-T-H-A-R, last name H-A-S-E-E-B-U-L-L-A-H. So the sort of nexus to the ACLU in connection with this is initially we were not a proponent when we saw the first iteration of the bill. In hearing Assemblymember Nadeem's story, as well as speaking to other candidates, we looked at the language and tried to find the most constitutionally permissible language available that would protect political candidates when they're running for office. And there's challenges associated with this. You very rarely hear me come forward to present bills that would create any level of a criminal penalty or potentially anything with a speech impact. But what we see here is a bill that's consistent with other provisions of NRS. Namely, what the bill would do under Section 2 is it would preclude the ability to communicate direct or indirect threats or intimidations to candidates for public office. Now, candidates is obviously defined as once somebody has filed for public office, they become a candidate for office. The preclusion would be to avoid or to preclude the ability to cause or induce another to cause threats, bodily injury to the candidate or a family member of that candidate, or physical damage to the property of that candidate, or a family member of that candidate. And they address that threat in a manner that places that candidate in reasonable fear that that threat or intimidation will in fact be carried out. Now, there's other NRS provisions theoretically that could apply to some of these, but the issue that often comes up for candidates, from what we've heard, is that sometimes things don't get done because it's dismissed as being political discourse. Now, I'm someone who gets regularly targeted as somebody who's a public figure with very vile threats, I will say. I have stopped reporting them in large part because nothing ever would happen, but I'm also not a candidate for office, right? I'm compensated to do my work professionally. For candidates who are running for public office, they should never have to face those types of threats, and nothing gets done. What's the difference between this bill and others is really Section 3, which is that a candidate who believes they've been subjected to the harms that's specified in Section 2 can file a complaint with the Secretary of State's office. We're grateful to the Secretary of State and Chief of Staff, Gabe DeCara, who was here earlier, had to head over to the Ways and Means Committee to address an issue there. But upon notification of the Secretary of State, their investigators would be able to investigate the incident, and if necessary, make a referral to the Attorney General's office for a determination as to whether or not they were going to prosecute. Now, it's not a binding requirement over the AG's office that they're required to do that. As lawyers, we know that they're required to do their own investigation, but the referral would be made. Most notably, though, is that Section 3, subsection 3. At the conclusion of the investigation, a written report would be given to the candidate describing the description of the alleged violation, the results of the investigation that's been undertaken, and, if applicable, the outcome of the referral of the matter. So at least candidates will know that there's something that's being looked at. I don't view this as a bill that's going to protect the ACLU or anybody in my universe, but we don't want to see candidates subjected to this kind of harm or anybody else. Particularly, political discourse is great. Once we start veering on the verge of death threats, which is what Assemblymember Nadeem faced and what we've heard of from other candidates, we don't want to run afoul of that and sort of like enter into a territory where that speech is not protected. The mens rea associated with something like this, obviously, is knowing, and that becomes significant for us as well. It's not just a disregard and recklessness and sort of the ordinary political discourse that might come up. For instance, an example of "I hope the person should die" doesn't necessarily imply what would be the threat in that instance, but saying that something along the lines of "we're going to kill this person," which is something that happens, or somebody else needs to show up to this person's house and take care of them in that type of way, right? It becomes a fact-specific determination, but at least there's parameters associated with it. And if nothing else happens, at least we know that it's being investigated. And Secretary of State's office does, in fact, have investigators. I think some folks weren't aware of that, and they're able to conduct those investigations. Again, this body, hopefully it's long-lasting policy that's made, and we don't run into those issues with pervasiveness, but this is a bill to help mitigate against that. With that, happy to answer any questions. I'll also note that there was initially a fiscal note on this by working with both the Attorney General's office and the Secretary of State's office. We were able to mitigate against those concerns and get this fiscal note removed as well.
Thank you very much, Mr. Hasibullah. Thank you, Assemblymember Nadeem. Members, any questions for our presenters? Senator Krasner.
Thank you, Chair. Thank you for your presentation. Why wouldn't the candidate, also, I'm very sorry that happened to you, Assemblymember. Why wouldn't somebody just report this to law enforcement? Please, Sheriff.
For the record, Attar Hasibullah, ACLU of Nevada. Senator Krasner, my understanding is that at least in a couple of the incidents I've spoken to, because people have reached out to us on this as well, they state that they have, and that nothing was done because they were viewed as a public figure and a public candidate for office, and so there wasn't even a full investigation conducted. I don't know if that changes county to county, but what I do know is that if it happens at all, It's a significant enough issue to where people are deterred from running for office, which we know you all sacrifice a lot to do so. I think that's demonstrated by the inherent challenges, but what I was told was effectively nothing gets done.
Thank you. And in that scenario where a candidate's been threatened with violence, and let's say they go to the local law enforcement agency, and if, let's say, the law enforcement agency doesn't think this is something they want to pursue, if this bill passes, could that candidate still go to the Nevada Secretary of State and possibly the attorney, you know, if it meets the requirements here, the Attorney General could still pursue that allegation of violence against the candidate?
For the record, Atara Cibula, ACLU of Nevada, that's correct. Technically, they have jurisdiction to be able to do so now. The intermediate step of having the Secretary of State effectively complete a report and also conduct an investigation and not leave it sort of in a discretionary fashion, it sends a notion of seriousness that's associated with it for them to be able to get a response and a result.
Thank you very much. Members, any additional questions? Okay, I'm not seeing any additional questions. Oh, Senator Steinbeck.
Yeah, and I'm sorry if I'm missing. Thank you very much for the presentation. And again, sorry that this happened like this. This is completely out of line and unacceptable. But as I read through this, so what is the level of punishment? What happens after it's found that that actually did occur?
For the record, Tahar Hasibullah, ACLU of Nevada, if I can go directly to Senator Steinbeck. Senator Steinbeck, if the offense is substantiated, it's prosecuted, it would mirror many of the existing provisions. The first offense would be a misdemeanor. The second or any subsequent offense is a gross misdemeanor. I think one of the things we struggled with doing this particular bill in terms of figuring out where to go was also gathering data. We don't actually know the number of threats that have been aggregated statewide that political candidates have faced. Through the use of this and our wonderful public records process in Nevada, we're hoping we'll be able to get assessments on that as well. If we realize this becomes a pervasive trend and doesn't push back against some of that, again, that's a conversation I think we can assess at some point later. Certainly once the harm is made or harm occurs, that falls outside the scope of the existing harassment statutes. And generally, I'll tell you, like harassment statutes from the ACLU of Nevada's perspective and on my end are oftentimes not the most comfortable positions for us to deal with as a hyper advocate of free speech. But what we've seen is things crossing boundaries. And when the bounds are crossed in that regard, we sort of start running into these walls where we have to be able to mitigate against some of these threats. So my hope is that at least with the report process that comes through within this finite period of time, we'll be able to say, you know, we only had one candidate or two candidates that ended up falling victim to these types of threats instead of hopefully not having, you know, whatever you all may end up facing and the volume ends up being much higher, in which case I think we'd have to come back and assess what we need to do here in this body.
Follow up with Senator Steinbeck.
So ultimately, though, it would go to court and a judge would determine whether or not that was a threat or it was not a threat. I mean, or a jury, correct?
For the record, Tahar Hasibullah, ACLU of Nevada, that's correct. This would require an investigation be committed or be completed by the Secretary of State, referral to the Attorney General's office for prosecution. The Attorney General's office would then have to investigate the incident, and if they chose to bring charges in court, they'd thereafter have to bring charges, and it would go through the ordinary court process. While it might seem onerous right now, the reality, including with what Assemblymember Nadeem faced, was that nothing was done. And we want something to be done here, and at least there's a step-by-step tracking process, so those threats that are made against candidates, real threats, you know, we're not talking about political hyperbole here, and there's language here that actually mitigates against political hyperbole, which is protected. But that's why a judge would be best positioned to take into account all of the factors that came through in the investigation and ultimately end up making a decision. So it would go through the court process. It wouldn't allow for any modifications where, you know, somebody was cited in a separate fashion. Due process would still be afforded in every one of these instances.
Right. And last one, Chair.
Please go ahead.
Because I could, and I'm in support of this, but you can see I'm going to crush my opponent, right? And things like that. Like you said, hyperbole, that someone will say one way and mean it completely different. And then that's why I'm glad that it is going to go to a court of law and then be adjudicated if that is necessary.
Yeah, and for the record, Atar Hasibullah, actually there's cases out there, including the Carpenter case, which has spoken on the specific issue. There's not necessarily always going to be a bright line litmus test for some of this, but certainly words and conduct do matter, and contemporaneous actions also matter. If there's no reasonable fear, for instance, that threat would actually be carried out, well, let's say somebody's not in the vicinity and it sounds as if that's not even going to meet the threshold for the minimum level of a standard here, but let's say that they do and there is imminence associated with it. The threats are, whether they're veiled or unveiled, there's an investigation that occurs. They're able to locate the person. That individual will be afforded due process, but if they are subject to prosecution, it would fall under these specific parameters. Political hyperbole will always be allowed because the Supreme Court's progeny of law has permitted that. What they have pushed back against in recent years has been those actions that go outside the scope of that.
Thank you, sir.
Thank you.
Thank you very much. Members, any additional questions for our presenters? I'm not seeing any additional questions. Thank you very much. And just to lay out for support, testimony, and opposition and neutral, because we do have to get down to the floor, I have to limit testimony today to 10 minutes for support, 10 minutes opposition, 10 minutes neutral. If anyone doesn't get the chance to participate, you can submit written comments. We'll make it part of the record. So Assemblymember Nadeem, Mr. Hasibullah, if you don't mind sitting in the chairs behind you, and then I'll open it up for support. Do you have something else you'd like to?
Just one final thing. Senator Orenshaw, I know this is going to be probably my last hearing before this committee this session. I wanted to thank the members of this committee for your graciousness always. And I wanted to thank you personally. A few weeks ago, we had put forward a resolution, and we had very extensive testimony that I was not expecting to come forward. And for about 80% of the folks that testified that day, that was their first time testifying. And so they felt included in the process. And so what you do really matters. And I just want to thank you all on the committee for taking the extra hour to listen to these people. So thank you.
Well, thank you very much, Mr. Hasibullah. I know at the legislature here, all our committees, we try to make sure everyone can participate. Everyone who wants to speak gets to be made part of the record. And it's hard to have to limit time today, but unfortunately, because sine die is approaching, because we've got to get to the floor, I have to limit time. But anybody who doesn't get to participate, please submit written comments to our committee. They will be made part of the record, and we will review them. Thank you. Good afternoon. Please state your name for the record and proceed.
Good afternoon, Chair Orenshaw and members of the committee. My name is Priscilla Gomez. That's Priscella, last name Gomez, and I'm the Democracy Manager at Silver State Voices. I'm here in support of AB 123 on behalf of my organization and the Let Nevadans Vote Coalition. At Nevada, all Nevada voters deserve to be able to take part in our democracy safely and without intimidation. That includes candidates who run for office without facing threats or harassment during their campaign because of their culture, religion, gender, and other aspects of their identity. This legislation is an important step towards ensuring Nevada has a political environment centered around respect. We urge the committee to support AB 123. Thank you.
Thank you very much for your testimony, Ms. Gomez. I don't see anyone else in Carson City coming here in support. I don't see anyone in the Las Vegas hearing room broadcasting. Is there anyone on the phone lines who wishes to speak in support of Assembly Bill 123?
Thank you, Chair. To testify in support to Assembly Bill 123, please press star 9 now to take your place in the queue. Chair, we have no callers in support at this time.
Thank you, broadcasting. I'd like to go to opposition. Anyone who's opposed to Assembly Bill 123, either here in Carson City or down at the Las Vegas hearing room. I'm not seeing anyone come forward. Broadcasting, is there anyone on the phone lines in opposition to the measure who wishes to be heard?
Thank you, Chair. To testify in opposition to Assembly Bill 123, please press star 9 now to take your place in the queue.
Good afternoon, or almost a good evening, and thanks for working so late and so hard. We appreciate it. My name is Iris Stone, IRISSTONE, and I represent myself. This bill duplicates NRS 200.571 under the rubric of harassment and stalking. The harassment clause outlines clear consequences in this statute for violations, which, by the way, are repeated almost verbally in this proposed bill. Isn't anyone subject to harassment equally victimized? While I condemn any harassment, the existing law applies to all Nevadans equally. It doesn't make sense to create a duplicate process tailored for political candidates. Candidates need to know that under NRS 200.571, they can escalate and get their harassment case adjudicated by the Nevada Attorney General. In addition, this bill, AB 123, brings the Secretary of State in the loop to take charge of the investigation. The responsibilities and duties for the Secretary of State, as defined in NRS 225, are limited to civil cases such as securities fraud, Ponzi scheme, investment fraud, election fraud, etc. Does not include criminal cases such as harassment or stalking. Therefore, let's remove the Secretary of State as the middleman and have candidates work directly with the State Attorney General's criminal investigation. And if the AG's office deems it necessary to engage with the Secretary of State, then let them be the judge. AB 123 is superfluous and should not be considered for a vote. Thank you for your attention.
Good evening. My name is Ellen Gifford, and as we pointed out before, Nevada already has a law addressing harassment, which is a crime punishable by imprisonment. Harassment includes threatening someone's life, among other threats of harm. This law applies to anyone, anywhere in Nevada, whether they're a candidate or not. In spite of the amendments to this bill and your discussion, it still isn't clear why this bill is necessary considering the existing law. Nevada also has a law that describes what a person can do to protect themselves if the crime of harassment is performed against them. This addresses the threat immediately. Was that information pursued by the assembly person? Thank you.
Chair, we have no additional callers in opposition at this time.
Thank you, Broadcasting. I'd like to go to neutral. Anyone who's neutral on the measure and wishes to be heard either in Carson City or down in the Las Vegas hearing room. Not seeing anyone come forward. Broadcasting, is there anyone on the phone lines in the neutral position who wishes to be heard?
Chair, we have no additional callers on the line at this time.
Thank you. Assemblymember Nadim. Mr. Asibullah, I'd like to invite you up if you'd like to make any closing comments. Thank you. Thank you for presenting the measure today.
So much, Chair Hanati Nadeem, for the record. I just want to say that thank you so much for the hearing, and I would love to. This is a very important bill, and I would love to have support, each and every one of you supporting this bill. Thank you so much.
Well, thank you for sharing what you went through. And again, no candidate who wants to serve their neighbors and their friends should have to go through what you went through. And Senator Steinbeck, do you have a question or comment? Please go ahead.
I do, thank you. And I just had a couple follow-up questions that came to mind. So one was what was discussed there, right, with some of the opposition about it being a duplicate bill, a duplicate law. And the other one that just kind of came to mind is that the Secretary of State or the Attorney General certainly wouldn't be immune from having this, being the victims of this as well. And would the expectation then be that they would recuse themselves or something along those lines?
For the record, Atara Sibule, ACLU of Nevada. First, with respect to the argument that it's superfluous, that's inaccurate. If it was superfluous, it would require all of the same provisions. Adding investigatory piece in Section 3, specifically a twofold investigatory piece with a required investigation by the Secretary of State, actually makes it a distinctive process versus what others go through. For instance, me as an ordinary citizen, maybe an extraordinary citizen, I could show up to the district attorney's office or law enforcement's offices, file a complaint, and the reality is it's unlikely to be summarily dismissed because I'm not a candidate for political office. It's different for political candidates, and we all know that. Political candidates are often subject to different rhetoric, different language, and different harm. So that in and of itself creates a distinction. The specific conflict piece, theoretically, that might end up existing is why we actually included the Secretary of State's office as one step within this process and also required the Attorney General's office to be the second step in that process. The reason why is if we only left this to the office of the Attorney General, and let's say it was an opponent of a candidate for attorney general, and it was only placed in one office, full authority to be able to do everything, you might run afoul. You wouldn't have a complete investigation on the front end, and then certainly on the back end, you might run into nefarious activities. We've sort of created a dual process, a dual role between two different executive branch officers, executive agencies, to be able to make that assessment. That way, we don't run afoul of any conflict of interest rules, and that way, if somebody is a candidate in one of those races, there's still the possibility that they'll be able to seek justice in that regard. Thank you.
Thank you very much. Any further questions, Ms. Senator Steinbeck or members? Nope. Thank you very much. Thank you for
again.
presenting the bill today. And again, no candidate should have to go through what you went through and these kind of vile threats just because you wanted to serve your community. Thank you. With that, I will close the hearing on Assembly Bill 123. The last item on our agenda is public comment. Anyone in Carson City or at the Las Vegas hearing room who wishes to make public comment, please come forward. We are limiting public comment to 2 minutes per speaker. Don't see anyone coming forward broadcasting. Is there anyone on the phone lines who wishes to make public comment?
Thank you, Chair. To provide public comment, please press star 9 now to take your place in the queue. Caller, please press star 6 to unmute.
Good evening. I'll be brief. My name again is Ellen Gifford. Before this legislative session ends, there is an issue that we hope can be addressed. In the process of reviewing numerous bills that have been introduced this session, it became so troubling to repeatedly see a section devoted to threatening citizens with the possibility of being guilty of a Category E felony and being punished, often with a prison sentence. It appeared over and over again to the point that it became almost sinister. Anyone knows that a law is a law and laws are not to be broken without consequences. Constantly inserting threats into bills that are written to introduce and explain a process takes away from the purpose and value of the bill's text. We hope this practice can be monitored to some degree. It is hoped the legislators can address this problem before the next legislative session begins. And I will end thanking all of you for your hard work this busy session. Thank you again.
Chair, we have no additional callers for public comment at this time.
Thank you. Members, we will be at ease for just a moment. With that, members, we will be adjourning. We will post call of the chair tomorrow. I'm not sure if we'll actually meet or not, but if we don't meet, members, it's been a pleasure getting to work with you. Thank you for all your thoughtful questions and the homework you've done on the bills and working so hard. Thank you to our staff, to Ms. Stanley, Ms. Summers, Suzanne, Ms. Efford, Mr. Sturm, Ms. Delosier, our counsel down in Las Vegas. We've had just the dream team here. They hear me joke about it because but there you are, the dream team. And I know sometimes I'm no picnic to work with, but it's been great working with our committee staff, and I think we've done so much great work this session. So we'll see. I'm not sure if we'll meet together in the room or just maybe a meeting behind the bar at the Senate. But thank you all for all your hard work this session, and thanks to everybody who's participated, who's commented on the bills. We really appreciate all the input from everyone on this legislation. With that, we are adjourned. Thanks.